The Federal High Court in Abuja will on Thursday, December the 17th, deliver ruling on whether to admit the leader of the indigenous people of Biafra and operator of Radio Biafra, Mr. Nnamdi Kalu, to bail. Justice Adeni Ademola gave the date after taking arguments from both parties involved in the bail application. Counsel to the CSS, Mr. Moses Idakwo, who reacted to the bail application sought by Mr. Kalu, asked the court not to admit the suspect on bail because he was allegedly involved in terrorism acts. The DSS counsel told Justice Ademola that the federal government was in possession of bank accounts of the accused persons for dollars and pound sterling from where he'd been financing terrorism acts against the country. Counsel to Nnamdi Kalu, Mr. Vincent Obeta, however, dismissed the claims of the DSS on the grounds that they were speculative and not supported with any documents or facts.
Praying the Honorable Court to set aside the order gotten by the SSS, mandating them to detain Nnamdi Kalu for 90 days. So we came to court and brought an application to set it aside. That application was actually taken on the last adjourned date, and the court adjourned today for the prosecution to argue their case on the basis of the counter affidavit. As you could see, it went well, because we were able to continue to advance the fact that you cannot have a right of audience in court when you are in disobedience to court orders. We've had plethora of cases from the Apex Court which says that anyone or any institution that is in disobedience to court orders shouldn't be given an audience in court. And it's on that basis that we came. Also advancing, coming from the point of the fundamental rights of Nnamdi Kalu, we were contending that any law that is inconsistent with the Constitution of the Federal Republic of Nigeria is null and void. And then we have placed our cards before the Honorable Court. There are areas to which I can't go in, otherwise I will be falling short of the law. Because once a matter is before a court of law, it becomes sub judice for me to go into the nitty-gritty of what has transpired. But in any case, we've been able to put our cards on the table, and then the prosecution has also argued their case. We've been able to also bring the clearer picture of what has been transpiring in this trial before the court, and we are hopefully waiting for the court to take a decision one way or the other. And we have adjourned for the 17th of December 2015 for the ruling of